that the restriction itself is narrowly tailored to serve that restriction, no more, no less. That's a good fit, this restriction, with the governing interest. Okay, that's the First Amendment analysis that applies if the law is content-based. Is the Espionage Act content-based? It singles out information relating to the national defense. So communicating information about antitrust matters or environmental problems, stuff like that, not covered by this law at all. Even though the information may be closely held by the government and they don't want to disclose, it doesn't relate to the national defense. Only information relating to the national defense is covered by the Espionage Act. So I take it is content-based. It singles out that content and prohibits speech of that kind. So it's content-based, therefore strict scrutiny applies. Therefore, the next question is this restriction, the Espionage Act restriction, does it serve a compelling government interest? What do you think? Information which could be used to the injury of the United States relates to the national defense. Is that a compelling interest? Mark? You say it's not narrowly tailored, but analytically, we need to know whether the government has a compelling government interest that it is narrowly tailored to fit. It's too broad to do what? Yeah. Are you conceding then that the government has a compelling government interest in preventing the disclosure of this kind of information? Everybody agree with that? No? Yeah. Okay. Well. Are you Ariel? Yeah. So you think information that betrays the president in a negative light can be covered by this law? That the president is weak vis-a-vis Iran, and disclosure that the president, for example, has instructed the Department of Defense not to prepare to bomb the nuclear facilities in Iran. That sort of information certainly relates to the national defense. Its disclosure could be used to the injury of the United States, I think. Not sure what Iran and other adversaries of our country might do with that information, but it could boomerang. I think you have to concede that at least some information relating to the national defense that could injure the country or give advantage, that the government does have a compelling interest in keeping that information confidential. And then the question is the statute narrowly tailored to serve that interest? And you've identified some of the big unknowns in how the statute may be applied. The word could, could, if it does injure the United States, that's one thing. But if it could, that invites speculation. But it's a little bit like prior restraint, requiring prediction that injury will befall us if this information gets out. The difference, though, from prior restraint is the Espionage Act is a criminal law providing for, after the fact, after the disclosure, punishment of the publisher, not a prior restraint that you can't do it. You got your hand up, Joe? How do they define injury? Oh, it's not defined. It has its common ordinary dictionary meaning. Well, you use the example, or how about when they were hunting Osama bin Laden? And if somebody leaked the Navy SEAL operational plan for breaking into the compound in Pakistan and catching bin Laden, somebody leaked that, would that injure the United States? The whole plan would be aborted. Our ability to catch bin Laden would disappear. He'd disappear. Would that injure the United States? I'd have to agree that it would. But there's enough loosey-goosey language in the law relating to the national defense. Could be used. Injury, I don't think, is terribly ambiguous for the law, but I think there's a serious question about whether the law is narrowly tailored to serve the interest in protecting national security. You may remember that when the Pentagon Papers were published, the Pentagon study, a classified study by the Department of Defense, they were leaked by Daniel Ellsberg to the New York Times, and when they were published after this epic battle in the Pentagon Papers case, the Nixon administration prosecuted Ellsberg under the Espionage Act. And as I said last time, the case against him was dismissed when the judge learned that the Nixon plumbers unit had burglarized Ellsberg's psychiatrist's office. So the case never went to the jury. And the government did not prosecute the Times. They prosecuted only the leaker, Ellsberg, and no publisher has ever been prosecuted under the Espionage Act. So what about WikiLeaks? Is WikiLeaks like the New York Times, or is it like Ellsberg? Bradley Manning, assuming he's the leaker, is like Ellsberg, seems to me. He's the government employee who betrays its trust, no matter how noble his motives. He's the one who gave classified information to somebody not entitled to have it. The government still may have some issues under the Espionage Act, particularly if they have to prove, and I'm not sure they have to do this in the court-martial, that he intended to hurt the United States or that he damaged the country. Manning, you can contrast Manning with Assange. Manning was a government employee. He violated his oath when he did what he did, so when he did it. Assange, he didn't have any security clearance. He didn't have any government job. He's not here. He's not a citizen, and he had no obligation not to disclose the information. So he may stand in different shoes than Manning. But if he were prosecuted as a publisher, what would we have to know in order to decide whether he's protected by the First Amendment? Well, it seems to me one of the things you certainly want to know is how he got the information. We'd like to have heard the conversation, if there was one, between Manning and Assange. Manning says, look what I got here. This stuff is dynamite. I've got 250,000 State Department things. Do you want them? And Assange says, you bet I do. Bring them on. And Manning says, well, it'll cost you $100,000. And Assange says, fine, check's in the mail. If he buys the information, essentially bribing Manning, or if he provides software to facilitate the leaks and so on, if he actively cooperates in getting the leaked information to WikiLeaks, then he could probably be charged with conspiracy, which is always a prosecutor's favorite, and might avoid the necessity of the government to prove a violation of the Espionage Act itself. But you really need to know whether WikiLeaks was a passive recipient of the leaked material or whether it actively engineered its disclosure. If it was just a passive recipient of the information, it was just like the New York Times in the Pentagon Papers situation, where the papers were delivered on a silver platter to the New York Times. Up until not long ago, WikiLeaks seemed to be inching away from the kind of anarchism that no secrets shall be allowed, that it espoused toward responsible journalism, maybe motivated by a desire to seek some shelter under the First Amendment. The website changed its tune. It says that its journalists now review leaked material and exercise some judgment about what it puts in the public domain. It hasn't forsworn indiscriminate dumping or hostility to any government secrecy, but certainly using responsible judgment gives it a better shot at First Amendment protection. These days, the WikiLeaks site is pretty pathetic. They're begging for money, saying that they've incurred $1,200,000 in legal expenses so far, and they need us. They're forced to put all our efforts into raising funds for survival and so on. They seem to be quasi out of the business of leaking at this point. I do think that whether they are protected under the First Amendment depends on both whether the leaked information is of legitimate public interest, and I think it is. Some of it certainly isn't. For example, if they exposed a mole in another country's government, outed a mole in another country's government by identifying a person, nobody needs to know who that person was. That's destructive. It's like the plane outing, where the Bush administration outed Valerie Plame. It doesn't serve any public need to have that information, who it was, and it's sort of gratuitous. But it seems like the material in WikiLeaks disclosures has been of legitimate public concern, like the Tunisia stuff and so on. And secondly, and probably more important, is the question of whether any actual harm was caused by any of the leaks. Remember that no harm was ever resulted from the publication of the Pentagon Papers. No harm ever resulted from the H-bomb secret published by the Progressive. Yeah. Well, causality would be proven. It's not possible to prove cause. I mean, that happens in lawsuits and courts throughout the country every day, that somebody has to prove the cause of their injury. It's a rear ender, and you have to prove that the other driver caused it. And there may be other causes that play into it, as Bickel argued in the Pentagon Papers situation, but you may well find a country that terminates relationships with us, terminates a treaty with us in reaction to the disclosure of information that wasn't ever supposed to see the light of day. Anyway, it's not impossible. But however all of these issues play out, let's hope, as I said in a little article in the Reader, that our own government's hands are clean. Lieberman, we know about. We don't have any evidence that the Obama administration was complicit in the developing the sexual misconduct charges against Assange after the 3 big leaks in 2010. Maybe just a coincidence that following those disclosures, Sweden issued this extraordinary international arrest warrant seeking Assange's extradition on a charge of failing to use a promised condom. I mean, that's really heavy-handed. Companies that supported the WikiLeaks site, like PayPal, Amazon, and so on, they may have decided independently, put aside Lieberman, that they didn't want to do business with WikiLeaks. The hacker attacks that followed on the WikiLeaks servers and wherever they were, maybe the hackers decided independently, without any encouragement from our government, that that's something they wanted to do. But it would be really distressing to learn that our government was involved in any of this. And imagine the irony if our government's complicity were established by secret government documents someday to be leaked through WikiLeaks. So on Thursday, we'll change gears again and go to some of the weirder kinds of disfavored speakers that the court has had to deal with in recent years.